Yes.
All right, for the jury.
All right, I'm waiting for you guys to start that thing where you switch seats on me. All right, everyone, please be seated. I hope you all had a chance to have a nice lunch. All right, State, call your next witness.
State calls CSI Perez.
All right, could you raise your right hand for me? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Please make sure you speak up so that the jurors can hear you in the court reporter. And you could state your name for the record.
Orlando Perez.
State.
Yes, Judge. Mr. Perez, how are you currently employed?
I am a crime scene investigator with the San Antonio Police Department.
And can you tell the jury a little bit about what you do as a crime scene investigator?
So we respond to scenes and we're there for documentation. We search, photograph, collect, and preserve evidence.
And how long have you been doing
Just about 14 years now.
that? Were you called to process a scene on May 25th of 2019?
Yes, I think so.
And do you remember the location that you were called to?
Not exactly.
And did you prepare a police or a report in this incident?
I did.
Would seeing a copy of that report refresh your memory?
Yes, please.
Your Honor, may I approach?
Yes.
I'm handing you what's marked as State's Exhibit 72. It's a copy of your report. If you could just refresh your memory, but don't read from it, okay?
Mhm.
And do you know now, after reviewing that, the address of the location you were called to process?
Yes, ma'am. 627 North New Braunfels.
And is that here in Bear County, Texas?
Yes.
Can you tell me what you did once you first arrived on scene?
Normally what we do is we'll get there and we kind of are guided by the officers, what they tell us, what they've seen and found, and then we'll go and we'll look and see what other evidence we find. And it gets photographed first and then marked and then collected.
And did you take photographs in this case?
I did not.
Did someone else take?
Yes, I had a partner out there.
And what was your partner's name?
CSI Melissa Hurst.
And while she photographed the pictures, were you by her
Yes,
throughout all of the photographs?
I would say yes.
Your Honor, may I approach?
Yes.
Okay, I'm gonna be handing you what's marked as states 3 through 71. Can you look through these and tell me if you recognize them?
Yes, I do.
And do they fairly and accurately depict the scene that you processed on May 25th of 2019?
Yes.
Your Honor, state would move to admit State's Exhibit 3 through 71.
I object, Your Honor, they're not properly authenticated. He did not take the pictures. He doesn't recall specifically if he was there the entire time while every picture was taken. So if we can establish, you can't establish proper predicate.
All right, that objection will be overruled. Counsel, do you need to see the photos?
I'll deal it on cross-examination.
All right, then State's Exhibits 3 through 71 is admitted.
And Mr. Perez, in addition to the photographs being taken, what did you do to process the scene on that day?
I was the one that collected the evidence.
Okay, and what evidence did you collect?
The majority of them are going to be spent shell casings, a couple projectiles, and a couple bullet fragments.
And the evidence that you collected that day, what did you do after you processed them?
We relocate back to the evidence office and I attempt to process them for fingerprints.
Okay. And after you process them for fingerprints, do you take them to the property room?
Correct.
And are you the one who placed them in the property room?
Yes.
Your Honor, may I approach you?
Yes.
Okay. Mr. Perez, you brought this envelope with you to court today, is that correct?
Yes, ma'am.
Okay, I'm gonna go ahead and mark that as State's Exhibit 73. And have you seen State's Exhibit 73 before?
Please, yes.
Yes. And when did you first see the contents of State's Exhibit 73?
You're talking about from when I put them in or today?
No, from originally, when did you first see the contents of State's Exhibit 73?
This is what I submitted, so.
Okay. Is it fair to say you saw them at the scene?
Yes, yes.
Okay. And how do you know that State's Exhibit 73 is the same object that you recovered on May 25th of 2019?
Because they should have these labels on them that I placed on them.
Okay, and are there any identifying marks on the envelope?
I should have, yeah, there should be the initials, date or batch number.
Okay, and do you see that on the envelope?
Not on these envelopes, because it looks like it, we have been, I mean, I guess it's probably what the proper best to collect them together.
Okay. So you're saying your signature is on the envelopes, which are inside of this big envelope, correct?
Correct.
Okay. I guess, can you go ahead and open the envelope? That way we can identify the items inside of it. Okay, perfect. And so each of those envelopes contain something that you collected on that day, correct?
Yes,
And each envelope has an identifying mark that you placed on it.
correct.
And is that your initials?
Yes.
Okay. Other than the identifying mark and which is your initials, has it been altered in any other way?
Doesn't appear to be now.
Okay. And is it in the same or substantially similar condition as when you placed it into the property room?
Yes, ma'am.
And how did State's Exhibit 73 get to the courtroom today?
I went and requested them and picked them up.
Okay. Let's go ahead and go through each little envelope so that we can put a exhibit sticker on them. And CSI Perez, how many items did you collect that day?
They're labeled as 17, but because one had 2 were marked under one number, there's gonna be 18.
Okay, and I guess let's start with the first one. Based off of your report, that is gonna be E1, correct?
Yes.
Okay, I'm gonna mark E1 as State's Exhibit 73A. And I'm gonna go ahead and have you open that and without showing the jury the contents of it, let me know if it's in the same or substantially same condition as when you collected it.
Yes,
Okay. And it is in the same or substantially similar condition as when you collected it?
yes.
And what is E1 listed as on your report?
I have this as a 1 Win 9 mm Luger side casing.
And give me just a second.
Oh, side casing.
Okay, CSI Press, let's move on to what's listed on your report as E2.
Mhm.
I'm gonna label that as States Exhibit 73B. And we're gonna go ahead and do the same thing. If you can just open it and let me know if the contents are in the same or substantially similar condition as when you collected it.
Yes,
And what is E2 listed as on your report?
also one Win 9 mm Luger casing.
And E3, I'm gonna mark that as 73, States Exhibit 73C. If you can open it again and let me know if it is in the same or substantially similar condition as when you collected it.
Yes,
And what is E3 on your report?
so this is it's one NIR 9 mm Luger.
E4A, I'm gonna list as States Exhibit 73D. If you can open it and let me know if it's in the same or substantially similar condition as when you collected it.
Yes,
Okay, and what is that listed as on your report?
that's also one NIR 9 mm Luger.
Okay. Item number E4B, I'm gonna label as States Exhibit 73E. You can do the same thing and let me know if it's in the same or substantially similar condition as when you collected it.
Yes,
And what is it listed as on your report?
NIR and 9 mm Luger.
Item number E5, I'm gonna label as States Exhibit 73F. If you can open it, let me know if it's in the same or substantially similar condition as when you collected it.
Yes,
And what is that listed as on your report?
one NIR 9 mm Luger.
Item number E6, I'm labeling as States Exhibit 73G. If you can open it and let me know if it is in the same or substantially similar condition as when you collected it.
Yes,
Okay, and what is that listed as on your report?
NIR 9 mm Luger.
Okay, item number E7, I'm labeling as States Exhibit 73H. Can you open it and let me know if it's in the same or substantially similar condition as when you collected it?
Yes,
Okay, and what is that labeled as on your report?
NIR 9 mm Luger.
Okay, item number E8, I'm labeling as 73I. You can open it, let me know if it's in the same or substantially similar condition.
Yes.
And what is that listed as on your report?
A win 9mm Ruger.
And item number E9, I'm labeling as 73, States Exhibit 73J. If you can open it and let me know if it's in the same or substantially similar condition as when you collected it.
Yes.
And what is that listed as on your report?
This is a projectile.
Okay, item E10, I'm labeling as States Exhibit 73K. If you can open it, let me know if it's in the same or substantially similar condition as when you collected it.
Yes.
And what is that listed as on your report?
NIR 9mm Ruger.
Item number E11, I'm labeling as 73L. You can open it and let me know if it's in the same or substantially similar condition as when you collected it.
Yes.
And what is that listed as on your report?
A projectile.
Item number E12, I'm labeling as States Exhibit 73M. If you can open it and let me know if it's in the same or substantially similar condition as when you collected it.
Yes.
Okay, and what is that listed as on your report?
A projectile.
Item number E13, I'm labeling as States Exhibit 73N. Can you open it and let me know if it's in the same or substantially similar condition as when you collected it?
Yes.
And what is that listed as on your report?
A projectile.
Item number E14, I'm labeling as States Exhibit 73O. Can you open it and let me know if it's in the same or substantially similar condition as when you collected it?
Yes.
And what is it listed as on your report?
A fragment.
Item number E15, I'm labeling as 73P. Can you open it and let me know if it's in the same or substantially similar condition as when you collected it?
Yes.
And what is that listed as on your report?
Also a fragment.
Item number E16, I'm labeling as States Exhibit 73Q. If you can open it, let me know if it's in the same or substantially similar condition as when you collected it.
Yes.
And what is that listed as on your report?
NIR 9mm Ruger.
And item number E17, I'm labeling as States Exhibit 73R. If you can open it and let me know if it's in the same or substantially similar condition as when you collected it.
Yes.
And what is that listed as on your report?
NIR 9mm Ruger.
Your Honor, state moves to admit State's Exhibit 73, as well as its contents, State's Exhibit 73A through 73R into evidence.
No objection.
All right, States Exhibit 73 and 73A through 73R are admitted.
Your Honor, may we have permission to publish?
Yes.
And Your Honor, may I help her with the technology?
Yes.
Seaside Press, I'm going to show you the pictures on the screen. You should be able to see them right up there. Cool. CSI Press, can you see the video on your screen?
Yes,
Okay. I'm going to show you what's been marked as State's Exhibit number 4. Does that appear to be the same storefront that's in the video?
yes, ma'am.
Now, when you were with CSI Hearst, you guys took several pictures that were outside of the storefront, correct?
Correct.
And this is State's Exhibit 5. State's Exhibit 6. Can you see what's in those photographs?
Yeah, somewhat. The parent casings right there.
And in this photo, you can see the items labeled, correct?
Yes,
And what are each of those yellow labels marking?
the casings that were located outside.
Okay, and are those what we just admitted that you have in front of you on your desk there?
Yes,
Okay. And so that would be E1 through E5, correct?
yes, ma'am.
So this is marked as 1. Is that what's going to be inside of your evidence marked E1?
Yes,
Same with this one, and this would be what's in the envelope labeled E2.
yes,
E3,
yes,
and does E4 have 2 casings inside of it?
they're separated, yes.
Okay, so this is the one that had E4A and E4B, correct?
Yes, correct.
E5, and a close-up of E5, and then E6, and a close-up of E6. Now, we're going to show you another video on your screen there. Now, these photographs, State's Exhibit 16, that is a photo of a vehicle, correct?
Yes,
And then in State's Exhibit 17, you can, oh, it's kind of dark on there, but in the close-up, you can see some damage to that vehicle.
yes,
Okay, based off of the video that just played for you, would you say that that would be damage that occurred from the vehicle striking it?
Objection, Your Honor, that calls for speculation.
Sustained.
You also took, or CSI Hearst took photos of the front of the vehicle. What are these pointing out, the white stickers?
the defects located on the vehicle.
And do you know what those defects are from?
So we just figured there were repair and bullet holes.
State's Exhibit 22, do you know what that is a picture of?
The defect on the windshield, I believe, or the window.
And what do you think what caused that?
Same thing as in the parent model.
Okay. And then there's a picture of the inside of, it appears to be the driver's seat.
Mhm.
What is that a photograph of?
The defect on the headrest,
And the back of the driver's seat?
right, another defect,
And would you say it's from the bullet hole as well?
right.
Okay, CSI President showing you what's been marked as State's Exhibit 27. And there's a yellow marker there indicating E7. What is that marking?
That is a spent casing on the floor.
Okay, CSI Press is State's Exhibit number 31. What is this a picture of?
That's towards by the register area in front,
But it's inside the store.
inside the store.
And State's Exhibit 32. Do you know what that's a picture of?
The defects on the wall, I think there's like a little bathroom in there,
Okay. Do you know what caused those defects?
probably the bullet holes or near bullet holes.
And State's Exhibit 34, is this inside the store as well?
Yes,
And what is it a photograph of?
the little refrigerator and the damage,
Do you know what caused the damage?
the apparent bullet holes or the apparent bullets.
In State's Exhibit 37, we can see some more markers on the floor. What are those listed as in your report?
Two are gonna be the casings and one will be a projectile.
Okay. And what is, so is that a picture of a casing?
Yes,
What is 9?
that projectile.
It's a close-up of 10.
The casing.
And CSI Press, what is this a picture of?
The closet or bathroom.
And do you know where that's located inside the store?
Yes, so you're looking at the registers to the left.
In based off of the video, could you Do you know where it was if we showed you the video?
Probably.
Okay. Do you know where the bathroom's located based off of that angle of the video?
I want to say it's like on this end, this side over here.
Okay. And State's Exhibit 43 is another picture of the restroom, correct?
Yes.
Here's one of your markers, item number 13. What is item number 13 listed as on your report?
As a projectile.
And in this picture, we can see item 14 and item 15. What is item 14 listed as in your report?
As a fragment.
And what is item 15 listed as in your report?
Also a fragment.
Okay, in State's Exhibit 49, what is this a picture of?
A sink.
And we see another one of your markers. What is item 12 listed as in your report?
Projectile.
And CSI Perez, we might have to switch back after I show you this, but State's Exhibit 54, what is this a picture of?
It's like a shelf that's on there.
Okay.
Oh, I'm sorry, and you mean the two markers are in there.
Okay, we got 16 and 17 here, correct?
Yes.
Okay, and what is 16 listed as on your report?
That's gonna be one of the casings.
And what is 17 listed as on your report?
Also a casing.
Okay, CSI Perez, what is this a picture of?
That's gonna be the wall by that bathroom.
Okay, and is that the sunglasses stand that we can see in the video that just played?
Yes.
Okay. What are the white markers in this photograph?
They're the rulers that are used to identify the defects on the wall
Okay, and what are the defects from?
from the bullets.
If you know, if someone is standing or behind this sunglass stand, would you consider these defects or the gun being shot in their direction?
Towards that sunglass stand, yes.
And I don't know how to zoom out on this, but State's Exhibit 33. Do you know what this is a picture of?
The defects on the wall from the restroom.
Is that inside the restroom?
I believe it's inside.
Okay, so would that be the back side or the exit of the bullet holes?
Right, the backside.
Okay. State's Exhibit 59 is a picture of your marker 11. What is number 11 listed as in your report?
As a projectile.
And CSI Perez, is this the wall that we just saw the backside of?
Yes, where the defects are.
And is this one of the markers that we've talked about just a second ago?
Yes,
And states exhibit 70 or 64, I apologize. Is that another one of those?
yes.
States exhibit 65. And I might have to approach you if you can't see it. Can you see the bottom of that T-shirt?
Yeah, so I had stored on here.
Let's see if you can see it on this one. Can you see what, is that a better picture? for you?
Right, yes.
Okay, and what does that appear to be?
The defects on the bottom of that shirt.
And is that from a bullet hole?
Right.
CSI Perez, can you explain to the jury what a projectile is?
Well, from what we were told is when the bullet comes out, the projectile comes out like casing the bullet, it needs to casing mounting, and the projectile is what comes out. Where I guess all the bullets.
And can you tell the jury what a fragment is?
That's just what we think comes from the bullet, it's a little piece of metal that's more than likely recognized as a part of the bullet.
We'll pass the witness.
All right, defense.
Was it Officer Perez?
No, CSI.
CSI.
Yes,
Okay. On the video you saw, it looked like the person in the picture entered the store a number of occasions.
you mean like more than once?
Yeah.
Right.
Yeah, okay. So the picture, can I see those, please? Specific one it was, the one with the sunglasses. Remember that one?
I remember the picture,
Yeah,
yes.
sunglasses. Can I approach, Your Honor?
Yes.
We don't know specifically at what time those shots were shot towards the sunglasses, do we?
Unless it's on the surveillance video, but I wouldn't know.
No, so it could have been the first time, the second time, or the third time. And we don't know where the people were at the time these shots were made, right?
Right.
All right. Now, did you obtain any fingerprints from any of the casings?
No, sir.
Did you do any ballistic tests on any of the casings or projectiles?
No, I don't do that now.
As a witness?
Nothing further, Your Honor.
All right, is this witness excused?
Yes.
Yes, Judge.
All right, thank you. State, call your next witness.
Judge, the state rest.
Def-
I just need to sign.
All right, thank you.
I'm ready, Judge, for your action.
State, you rest.
Yes, Your Honor.
Defense.
Defense rest, Your Honor.
State, do you close?
Yes, Your Honor.
Defense.
Defense closes, Your Honor.
All right, could I have parties approach, please? All right, ladies and gentlemen, you've heard all the evidence that you're going to receive in this case. So what I'm going to do now is read for you the jury charge. You will be given this charge back with you once you begin your deliberations. Charge of the court. Members of the jury, the defendant, Kenneth Williams, stands charged by indictment in counts 1, 2, and 3 with the offense of aggravated assault with a deadly weapon. The defendant, Kenneth Williams, stands charged by indictment in count 4 with the offense of deadly conduct. All of the above offenses are alleged to have been committed on or about the 25th day of May 2019 in Bexar County, Texas. To all of these allegations, the defendant has pleaded not guilty. Number 1, our law provides that a person commits an assault if the person intentionally or knowingly threatens another with imminent bodily injury. A person commits the offense of aggravated assault with a deadly weapon if the person commits an assault as defined above and uses or exhibits a deadly weapon during the commission of the assault. Number 2, our law provides that a person commits the offense of deadly conduct if he knowingly discharges a firearm at or in the direction of one or more individuals. 3, deadly weapon means a firearm or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion of burning substance or any device readily convertible to that use. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss of impairment of the function of any bodily member or organ. 4, a person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. 5, now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 25th day of May 2019 in Bexar County, Texas, the defendant Kenneth Williams did use or exhibit a deadly weapon, namely a firearm, and Kenneth Williams did intentionally or knowingly threaten imminent bodily injury to Martin Garcia by shooting at or in the direction of Martin Garcia with said deadly weapon, then you will find the defendant guilty of aggravated assault with a deadly weapon as charged in count 1 of the indictment. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 1. 6, now if you unanimously find from the evidence beyond a reasonable doubt that on or about the 25th day of May 2019 in Bexar County, Texas, the defendant Kenneth Williams did use or exhibit a deadly weapon, namely a motor vehicle, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and Kenneth Williams did intentionally or knowingly threaten imminent bodily injury to Martin Garcia by driving said deadly weapon at or in the direction of Martin Garcia, then you will find the defendant guilty of aggravated assault with a deadly weapon as charged in count 2 of the indictment. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 2. Number 7, now if you unanimously find from the evidence beyond a reasonable doubt that on or about the 25th day of May 2019 in Bexar County, Texas, the defendant Kenneth Williams did use or exhibit a deadly weapon, namely a firearm, and Kenneth Williams did intentionally or knowingly threaten imminent bodily injury to Mohammed Al-Qasim by shooting at or in the direction of Mohammed Al-Qasim with said deadly weapon, then you will find the defendant guilty of aggravated assault with a deadly weapon as charged in count 3 of the indictment. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 3. Number 8, now if you unanimously find from the evidence beyond a reasonable doubt that on or about the 25th day of May 2019 in Bexar County, Texas, the defendant Kenneth Williams did knowingly discharge a firearm at or in the direction of individuals, namely Martin Garcia and or Mohammed Al-Qasim, then you will find the defendant guilty of the offense of deadly conduct as charged in count 4 of the indictment. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 4. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. Written or recorded statements made by a witness to investigators or other officers or police reports made by officers intended by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can only send statements and reports received in evidence to the jury room. The grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in determining whether the defendant is guilty or not guilty. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. Do not let bias, prejudice, or sympathy play any part in your deliberations. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, or computer, the internet or any internet service, or any text or instant messaging service, or any internet chat room, blog, or website to communicate with anyone any information about this case or to conduct any research about this case until I accept your verdict. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony, but the law of the case you must receive from the court as contained in these instructions and be governed thereby. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact or verdict to be reached in this case. No such indication was or is intended. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate form attached to this charge and signing his or her name as presiding juror. The form is not intended to suggest to you what your verdict should be. Your sole duty at this time is to determine whether the defendant is guilty under the indictment in this cause and restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. If the jury wishes to communicate with the court, the presiding juror shall notify the bailiff. Any communications relative to the case must be written, prepared by the presiding juror, and shall be submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Borden, 187th District Court. Verdict forms are attached. State.
Ladies and gentlemen, yesterday during court ire, we told you that in order to find the defendant guilty, we would have to prove each and every element beyond a reasonable doubt. The elements that we had to prove to you for this offense are that on or about May 25th of 2019 in Bexar County, Texas, the defendant, Kenneth Williams, committed an assault by intentionally and knowingly threatening serious bodily injury to Martin Garcia and Mohammed Akasem by driving a motor vehicle at Martin Garcia and by shooting a firearm at or in the direction of Martin Garcia and Mohammed Akasem. And the motor vehicle and firearm are deadly weapons. In addition, the elements of deadly conduct are that on or about May 25th of 2019 in Bexar County, Texas, the defendant, Kenneth Williams, knowingly discharged a firearm at or in the direction of Martin Garcia and Mohammed Akasem. Those are the only elements we have to prove to you. We also went over what we don't have to prove to you. Anything that is not listed on those elements is not something that we needed to or are required to prove to you. We also don't have to tell you why or prove to you why the defendant did this. Our burden of proof, which stays with us throughout the entirety of the trial, is beyond a reasonable doubt. That does not mean with 100% certainty. And it doesn't mean beyond all possible doubt. It is beyond a reasonable doubt. Marcus and I believe that we have met that burden and proven to you each and every element beyond a reasonable doubt. Now, when you go back to deliberate, you'll be able to take back the evidence with you. That includes the videos, the photos, the projectiles, and the casings. We mentioned several police reports and labeled those as state's exhibits. You cannot take those back with you. It's not that we don't want you to take them back with you, it's just the law, okay? Everything you heard from the witness stand, that is evidence as well. So you're gonna take back all of the physical evidence as well as the testimony you heard. After I sit down, the defense counsel is going to get up here. He's gonna present to you his closing argument, and then Marcus is gonna come up and present to you the last of our case. Remember that you are the sole jurors, and you get to assess the credibility of the witnesses. You can only consider the evidence that has been presented to you today. Marcus is going to speak to you, and after he's done, we're going to ask that you find the defendant guilty.
Defense.
May it please the court. Good afternoon, ladies and gentlemen of the jury. Before I start off, I want to thank you for your service here, because what you do is valuable. Everyone's entitled to a jury trial of their peers. That's in our Constitution, that's in our history. What's also in our Constitution is the right to confront witnesses. It's in the same amendment as the jury. Right to jury, the 6th Amendment. Here's Martin Garcia. We look at the indictment, and they've alleged that he tried to run over Martin Garcia. You look at the video, and Martin Garcia aggressively comes after him. Martin Garcia stands in front of his vehicle, and the vehicle drives away. Was it knowingly, intentionally using that vehicle to commit an aggravated assault? Or was Martin Garcia standing in front of the vehicle and the individual driving that vehicle wanted to get away because he was aggressive? 2, Muhammad. Yeah, Muhammad was in the store, but where was Muhammad when the shots were fired? The initial video, the shooter comes in straight in, starts shooting straight away. Muhammad is back on the counter over here. Then the shooter comes back in, starts shooting the other direction. Muhammad has moved all the way, is now on the far end of the counter. Detective Porter testified that all the witnesses testified they were not threatened
Your Honor, I'm gonna object. That's a misstatement of that.
No, it's not. It's in the record. I asked,
Let me respond. Ladies and gentlemen, jury, you will hear you will remember the evidence as it has been heard. You may proceed, and your objection will be overruled.
I asked Detective Porter if, I think it was Vasquez, was still a threat. No. The other individual, I can't remember the name, was he threatened? No. And anywhere in your police report, did Muhammad say he was threatened? No. So when we look at the jury charge on 5, the first one is Martin Garcia. He's not here. We don't know the story of Martin Garcia. We don't know what was said, what was threatened. The defendant has the absolute right to cross-examine him, to question him. He's not here to do that. The automobile, that is, I believe, paragraph 6. Martin, it's clear as day, Martin Garcia is the aggressor. He comes after him, he punches him. He's standing in front of the automobile and the automobile is trying to drive away. Is that aggravated assault with a deadly weapon, or is that some guy's an idiot? Muhammad, we've talked about. He wasn't threatened. In fact, you can see he has his camera out, his cell phone taking video. So when you go back to the jury room, you need to look at all the evidence involved and use your common sense, put 2 and 2 together. Where's Martin? Has the state proved everything beyond a reasonable doubt? I said all the elements of the case and all the counts of the indictment. Once again, ladies and gentlemen of the jury, I thank you for your time and your service.
Next state.
Thank you, Judge. Ladies and gentlemen of the jury, sometimes it really is just that simple. We don't want to waste your time, but it's an important case. Every defendant is entitled to draw, and they're entitled to have us, the state, prove our case to 12 years, their peers, and that's what we did in this situation. Now, defense brought up a few times the right to cross-examine witnesses. It's not that he has the right to cross-examine a victim. It's witnesses, the ones who take the stand, and he did that. Martin isn't a witness in this case. The witnesses were Muhammad, Sergeant Porter, CSI Perez. You know who else is a witness? That video. But he can't cross-examine that because that's clear. You see it, you believe it. So let's talk about some of the evidence that you heard. You heard from Muhammad. He testified that he knew the defendant, Kenneth, because he dated one of his coworkers. He identified it near court. There was no doubt that it was Kenneth on that day. He spotted him in the video. He told you the background story, that Kenneth and Martin were arguing, that Kenneth, the defendant, said, I wanted to talk to you outside. And then when they went outside, that the defendant tried to run over him with his car. He said that the defendant then left, came back later and started shooting. At no point did he waver or say that, oh, it was someone else. The entire time it was Kenneth. Also, one thing I want to remind you all of is that we talked about inward diary. I gave you the example of the robbery and Spurs game in which you need to hear from every witnesses, and all of you said no. In fact, all of you said that you could find someone guilty based on only one witness if that witness proves all of the evidence you can ever report out. Another thing that we talked about was why some witnesses may not show up. Could be scared, they could be gone, who knows? But as we talked about, we can still prove our case without certain witnesses, and that's what we get in this situation. You have the videos, you have the photos, all of that's going to go back there with you. I want to go through the counts that were alleged, and I'm going to go through them chronologically. So first, count 2, aggravated assault with a motor vehicle, the victim, Martin Garcia. As you can see, this is the vehicle, State's Exhibit 17. You can see the damage on State's Exhibit 18. The video on State's Exhibit 1. Now, defense mentioned that the victim, Martin Garcia, was standing in front of his vehicle, and that Martin Garcia was the aggressor. And I told all of y'all that in open, Martin was the aggressor. He went after the defendant in the situation. But that doesn't mean that the defendant can then escalate things even more and try to run him over the vehicle. And defense started to say that, oh, he was just standing in front of him and he was trying to drive away. You know that's not true, because you can see that he could back up easily. And then you know what else? You can see that Martin tries to move out of the way and the defendant swerves. So first Martin is on the right, defendant goes to the right, and that's when he hits the vehicle. Martin goes to the left, defendant goes to the left, and almost runs into the building. He wasn't trying to get past him, he was trying to hit him, he was trying to run him over, and that's what he did. He committed an aggravated assault, and so we've proven this count 2 aggravated assault against Martin Garcia. We've hit every single element that we're required to prove by law. Count 1 aggravated assault firearm against Martin Garcia. This is State's Exhibit 14. This is the bathroom that you saw in the video that Martin Garcia ran into. State's Exhibit 13 is a projectile. That's how you know that he was actually, it wasn't some fake gun, or there's no doubt that it was a firearm. There's projectiles in the bathroom, and you saw it in the other picture where it hit the wall. You can see in State's Exhibit 46, 15 was a fragment, 14 was a fragment, and you can see in the bottom corner that the toilet is broken. You can see broken pieces near State's Exhibit 14. That's how close those rounds came to hitting Martin Garcia. We wouldn't be looking at an aggravated assault right now. It would be a murder case. Fortunately, no one was hit, but no thanks to the defendant. That's 15. And then those are the bullet holes that Brittany went over in the wall. State's Exhibit 32 and State's Exhibit 33. We proven count 1 for that on that date, May 25th, 2019. The defendant, Kenneth Williams, committed aggravated assault by firing a gun at or in the direction of Martin Garcia. This is that video. As you can see, he runs in. And this is the other video. Y'all seen it numerous times. I'm not going to play it again, but you'll have it to take back with you. Count 3 aggravated assault against Muhammad Al-Hussein. Now this is a little bit different because we don't think that he was trying to necessarily shoot Muhammad. Muhammad's a regular guy working at a cashier at a convenience store over close to the east side, like I said, 10 minutes from here. He's just going to work trying to do his job. He shouldn't be a victim of an aggravated assault. He shouldn't have bullets flying past his head. And he testified that he was right there, that he could hear the bullets whizzing by him, that when he dug down on the ground, he could hear and feel the debris from where the bullets were hitting. Those bullets were shot at or in this direction. There's no doubt about that. As you can see, State's Exhibit 9, as CSI Press testified, that was a projectile. That was one of the rounds that went in that direction. State's Exhibit 61 shows another item that was collected, another projectile.
5 minutes.
Thank you, Judge. That went in the direction, because there's that glasses case that you saw Muhammad hiding behind. This is Muhammad right here. These are the t-shirts that Muhammad was, that you can see in some of the State's Exhibit photos. This is that glasses case. Muhammad is right here, and he feels the bullets going by, he feels the debris, and so he backs up, tries to get to a safer area. I want to point out one thing. So this is that same video. And I want to slow it down a little bit. When you see the defendant run in, watch these shirts. You can see them moving as they get hit. This is Muhammad right here. see the glass being shattered and the sheriff's moving. That's when Muhammad backs up. And you'll see it again, it happens. Shooting at that wall, trying to hit Martin Garcia, but he's still shooting at or in the direction of Muhammad Garcia. We've proven that on that day he committed an aggravated assault against Muhammad Al-Hussein. As I said, all of you were chosen because you said that you could follow the law, that if we proved our case to you, the honor would put out for this one witness, no witnesses that you would find yourselves guilty. That's what we did in this situation. From CSI veterans, you heard that over 12 cases were fired. 12 daily rounds that could have gone anywhere, if anyone. We can't have that in this community. Those type of actions aren't acceptable. Fortunately, like I said, we're here for only an aggravated assault, but this could have been so much worse. So we're asking you that you follow the law, that you face your verdict on the evidence, and that you hold Mr. Williams accountable for his actions and that you find him guilty on all counts. Thank you.
All right, ladies and gentlemen, you've heard all the evidence in this case. Now I will send you back with the deputy to begin your deliberations. If I could have Jesus Garcia and Michael Janowski to remain behind, please. All right, everyone, please rise.